Good evening, everyone. Welcome to our weekly Wednesday webinar with the Property Law Alliance. We are pre-recording today because we have someone's birthday today. Bruno, happy birthday. I hope you had a wonderful day and may this year be filled with blessings. And I think I speak on behalf of all our viewers that we really appreciate you and all your effort with the industry, but a happy birthday, and I really hope you have a lovely evening and a lovely year ahead.
Wow, thank you so much. Such kind words.
Yes, you deserve it.
I was so excited when she started talking. I thought she's going to sing happy birthday, but unfortunately not. But happy birthday, Bruno.
Thank you.
I concur with Marily. I really believe the things that you are doing for the industry is really amazing. So I'm just echoing what she is saying. Really happy birthday and thank you so much. And I hope the year it is even better and more spectacular and filled with easy, straightforward, unopposed evictions.
Wow, yeah. Now that would be a gift.
From one eviction lawyer to another, this is how we say happy birthday.
All right, but welcome you guys and thank you so much for joining me this evening. And then I also want to make use of this opportunity to thank both of you as well as Greg in his absence, that I think I speak on behalf of all our viewers that we would not have made it through this year without you guys. So thank you so much for all your effort with all the COVID issues and everything. It's definitely much appreciated.
So thanks so much.
And right back at you, Marily. Remember, every Wednesday we are here, so are you. So thank you so much.
Yeah.
Actually, I've missed a few, and yet you are still here. So thank you very much to you too.
Yeah. No, without you, Marily, we wouldn't know what the hell we're doing.
It's only a pleasure. All right.
I think it's. Sorry, Marily, I think it's relevant to say to everybody why we're being so appreciative of each other, because we are heading towards the end of the year. So it's not our last episode yet, but next week will be. So we're just preparing everybody to wrap up this year.
Definitely.
People need to be prepared. We're very happy now. January starts off grumpy. So like you get as much as you take. Yes.
And so now I think you definitely have the festive season vibe going on there.
I'm ready. And with the sun shining on that exact direction, it makes me even look like a little Christmas angel. So I've got all the Christmasness going. I'm trying to dodge the sun. So if I do funny moves, just smile politely and look at my Christmas tree.
All right, perfect. All right, guys, then I think we can get started on today's topics. First, what I want to discuss is court dates. So I know we have discussed this previously, but what type of dates are we looking at? Are you getting any court dates? So what is the current situation? I don't know, Bruno, if you maybe want to get started on that.
So at Randburg Court, which isn't too bad, we did some evictions there just to kind of test the water in case High Court let us down. So Randburg, I think we got 19th of January. The next day, today we got the 19th of January, so that's not too bad. Especially with Christmas right in between. So that's actually quite a great date. High Court, I need to ask my attorneys there. I know that it's still a bit of a mission, so it's not coming as soon as we'd like. So if memory serves, it's probably around, I think if we're lucky, we got something at the end of Feb. But I just need to check. So the High Court is being a bit funny, but I think this is something that we're going to touch on today. All us attorneys got reprimanded. Because slap on the wrist. Yes, slap on the wrist. Because apparently we did too much, and the courts are a little bit upset with us now.
That is unfortunate.
I think I have to elaborate on that one.
Yeah. I was going to give you the opportunity.
I'm like, Whoa, it sounds like we're in deep trouble, but luckily it's all of us. Um, so we are in trouble. I think you will remember, I think about, when was this? If I recall correctly, must have been about 4 weeks ago, 5 episodes ago. We've discussed the issue that we're having about case lines, the system that we're currently using to get matters on the roll and in front of court. And the problem that we were having is you can't go to court. So you can't send your messenger to court like you normally do, or your candidate attorney or whatever. You have to email a specific email address, one option, and they will give you a court date. And if it doesn't happen, if you don't get a reply, we were told, and the directive says, you're not allowed to send more emails. So you basically send this email requesting a court date. It's then from that point a matter of faith whether you're going to get a court date or not. So apparently that wasn't really working that well. So what we started doing, and by we I mean Bruno did that, SSLR did that, I'm quite sure Greg would have done the same thing. We started sending our messengers back to court to go talk to the registrar and get dates. The problem, and this is now where we got reprimanded, there was a circular sent on the 27th of November by the judge president to all the legal practice councils, to all the attorneys associations, to all the bar councils, and we were definitely reprimanded. It was like being called to the principal's office, almost like that talk that the president had with us the other day about wearing masks, and we were all like, sorry. And so sort of the same thing happened here. The judge president had a bit of a go at us. We were in the principal's office. And the reason for this is the judge president said, guys, please don't do this. Stick to the regulations of the 18th of September, which says you're not allowed to go to the registrar's office. And so that's a bit of a surprise, Bruno. Now that we know we're in trouble, nobody apologized. We all just like, well, I mean, we all just like, okay, but what now? Because now what if you don't get a court date? So I feel like we're a little stuck where we are. What's your position?
So look, so obviously I can't speak for the rest of the fraternity because I don't know how exploitative or abusive everyone else was, right? So there might be some logic to the judge president saying, you know, we were just overwhelmed with so many people and people were going in there and they were insisting. But I know from our perspective, like we were reasonable. We still tried to send the emails. We waited. We didn't get a response and we said, great, we're going to follow up. So, if you look at it from a good faith perspective, we weren't trying to circumvent the rules. We weren't trying to beat somebody else to the punch. We were going, well, no one's answering the emails. We can't send repetitive emails. We now need to go and ask and say, well, what's happening? Can I please get some kind of engagement from you? If you respond to the emails, by all means. So I think what you're saying about, us as attorneys not apologizing. So the tone of the directive was quite strong, fair enough. But then our response to it wasn't to say, listen, you know what, we want to ignore it, but we can't also be apologetic when we don't feel that the system is geared to properly deal with it to begin with. I mean, I think it was about 4 or 5 weeks ago, I was telling you guys about when the system crashed and we were getting delivery errors, and we actually had matters on the roll that we couldn't deal with because, oh, sorry, it's not on the roll today. We didn't get the emails. Yes, and the system crashed, and there's nothing we can do about it. Then come up with something. Then there has to be some kind of automated system, a little calendar system where you can click and a date pops up. And I suppose that's where we are a bit unapologetic because we don't have options or recourse or something that we can do. So we are going to keep pushing. And I suppose that's the thing. Yeah.
And I think a very big thing is every time we tell our clients, this is the position, we really can't get a court date. I can definitely see my client thinks, seriously, you must be joking. Like, it can't possibly be the position. So I think one of the bigger things is we are forced to find alternative ways, but now unfortunately our alternative ways were shut in our face. I wish I knew what to tell clients, because we've had clients now towards the end of November, early December, where we told them, don't stress, we're currently getting dates. We'll have a date in about a week or so. And now we go back to them and say, sorry, nothing. And they're like, but can't you do something? And then you have to say, no, I have nothing. I think the level of frustration about the court system at this stage is really reaching a very intense point, especially because I don't know about what your experience is, but I'm definitely getting the feeling that clients are already very frustrated in an eviction process. And currently, with the court, the way the courts are functioning, it's just making it so much worse. So I wish there was something that we can tell clients to make them feel better about this situation. But I think at least if we openly talk about it and everybody knows what's going on, I think already it's if you know it's not just you, at least you feel a little better.
No, absolutely.
Or at least team frustration.
No, absolutely. Look, and I mean, I get it. Some of our clients actually rely on rentals. So even if our clients are the estate agents, they're getting the pressure because their landlords need the money. So a lot of guys rely on this. It's not just about making more and more money, and you've got rich people all over the place that let properties out. And this is also about sustainability. Some people intentionally go by just to get a bit of income every month to supplement their work income. What's very interesting, and I mean, if anyone from the judiciary ever listens to one of these shows, which I promote greatly, what I don't quite understand is the introduction of case lines was a great concept, but having this document management system is quite complex, admittedly, very, very complex, having to upload, make sure everything's in place. But a simple calendar system couldn't be implemented first. We couldn't have taken a sort of a baby step and saying, listen, you know what, we still don't mind you delivering a bundle pack at the court into a court file that a judge can collect, take home, sit on Zoom and open up in front of him. But at the very least, have a little calendar system that shows slot taken. Oh, open slot, click. And then you take the slot, and each firm is entitled to take X amount of slots per week or per day. And
I like that.
Something as simple as that, because it exists. It's not novel. It doesn't take a brain surgeon or a rocket scientist to figure that one out. It's right there. But I suppose that's the frustration, is they went here and then they kind of missed everything down here.
Exactly. Like, I mean, a lot of beauty salons uses this system, and my doctor uses this. You can't call my doctor to make an appointment. You have to go online to book an appointment. And I like your Black Friday and COVID stock up shopping limits on X amount of dates per firm. And
absolutely, yeah.
I like that. I'm like, yes, that's pretty. And then in fairness, the firms have the ability to line up their appearances on one day, which makes it more cost effective for them, makes it more cost effective on billing for the client. So it's actually quite a valuable thing. But unfortunately, we lawyers are not IT people, and that sort of shows when it comes to the way we are doing this.
Yeah, fair enough.
All right. And in addition to that, the technical difficulties, we are at the end of the year. So the term dies non, what does that mean? Does it have an effect on court dates? If you can maybe just explain that to the viewers, to explain what it is and what the effect thereof is. I think, Silna, if you can get started on that one.
Yes, definitely. So dies non, it's simple. It's a Latin term to say, so dies is days, counting days, and non is not rocket science. It doesn't count. So basically, dies non means in that time period, we are not counting court days. So in all civil procedure matters, we have a certain time limit in which we must do certain things, in which time we must reply, in which time we must respond, things like that. And dies non simply means for that time period that stops. So if you have to deliver your plea in 20 court days, that in dies non, you don't count that, it counts as nothing. So you just stop your counting for that time period and you continue after that. So in terms of the rules, usually dies non is around, it starts on the 16th of December and it usually runs until the until the second Monday in Jan. So we got a new directive today from the High Court. Bruno, I'm going to pass the ball back to you on that one.
I think it was 15th to the 9th, if I'm not mistaken.
Yeah, 15 to the 8th. So starting on the 9th.
To the 8th, yeah.
Yes, 100%.
So this is so this is from the Constitutional Court. So a debate that attorneys always have is the Constitutional Court issues this dies non, but it's up on the Constitutional Court. So if you're ever having a Constitutional Court matter, it's an excellent directive. The problem is that not all courts do the same. So I find that the labor court sometimes does it, but not all courts issue the same type of directive. So sometimes there's a little bit of uncertainty as to what happens in some of the lower courts, because there are certain rules regarding dies non, regarding pleadings, but not necessarily all court documentation. And there's no specificity as to what happens with some of these documents. So some things may actually remain due, not on public holidays though, because with courts, you only work on actual court dates, not normal days. So not public holidays, weekends, things like that. So we are heading towards public holidays, which make it a little bit easier, but you might be in a situation where technically some of the time periods do run out. But as Silna and I had, like we discussed, that this does come down to a question of getting along, Ubuntu, whatever you want to call it, where, let's not be difficult. Let's not make each other's lives difficult. You know what I was going to say, and then I actually looked at a different way of saying it.
I am impressed. You reined him straight back in. Don't be a bad guy.
So ultimately there is this collegial approach amongst attorneys when it comes to things like that. I've never yet to this day had an attorney that tried to force something on over the Christmas period. Even over COVID, people tend to be a bit more amiable or amicable when it comes to things like that. The problem that I experience sometimes is it's not your attorneys, it's your lay persons. So those persons representing themselves when they read something in the rules and they try and enforce it. But that rarely happens, especially with us, where we're normally the people instituting the proceedings. So I think for our clients, they just need to understand over this period, there's going to be a break, and almost nothing's going to be able to happen.
I think that's such an important point, Bruno, because usually people talk about, but the courts are closing. So I think it's important for our viewers to understand the courts never close. You always have access to the courts. Urgent court will always be there. So if there's a crisis that you need to get to court urgently, for instance, in the case of an interdict that you need to get, a landlord that's harassing an occupant that's threatening to set the place on fire. We always have that. We always have the urgent court to go to. But if you are in this time and you try to get to an urgent court, you need to be extremely sure that it's super duper urgent. Exactly. And it's not commercial urgency. So it's not, I am losing money. It's like irreparable harm is the term that's used in court. So unless you can prove that you're going to suffer irreparable harm, you're not going to get into court. Unopposed motions are still there and still running. The only problem with that is we already just said that we're struggling to get court dates because the registrars is already sort of getting into like me. more Christmas spirit, which makes it a little difficult to get things done. And unfortunately, we're starting to already get the notices from the sheriffs that they're going to close. I've actually had I'm just looking at my calendar now. We've actually had a notice from one of the sheriffs that they're already closing on the 11th of December. So again, for our viewers' benefits, I'm glad you're pulling that face, because that was my thought. And I thought I'm just being, not in a Christmas spirit. So the problem is the sheriffs, once again, are forced to still do urgent service. But similar to approaching a court on an urgent basis, you need to pull a pretty impressive, cute little rabbit from a hat to get the sheriff to attend to what you need them to attend to. And if they're already starting to close on the 11th, Bruno, I think we're going to have a pretty long December.
Yeah, no, absolutely. I still don't understand. Yeah, I was actually under the impression that people would be using this December to make up quite a lot of losses. And I have found that, some offices are closing a lot later than usual. But from a sheriff's perspective, there's still a lot of work that needs to be done. I even anticipated that the courts would kind of shorten recess because of all the time that we've lost and the backlog and that sort of thing. But again, I'm not here to try and be critical, but it almost just feels like everything's compounding and people are getting frustrated and no exceptions are being made to try. Yeah. So, but anyways, I digress.
All right, perfect. Thank you for that. And then the next question, I'm going to read the scenario to you guys and then we can discuss it. So there is a flat that was sold with the current tenant in place and the transfer took place and the rental is being paid to the new owner now. However, the flat is still furnished with the previous owner's furniture until the lease ends in March 2021. Now, the question is, who is responsible, for instance, if the fridge gives problems or if there's any other issue that comes up with the furniture? Who's responsible to fix it whilst the tenant is in the place if the new owner didn't want the furniture? So is the new owner responsible for that or the previous owner? I think, Silna, if you maybe want to get started on this one, then we can move over to Bruno's views.
Yes, so this is actually a very interesting one. I think we're answering to pretty much the entire Remax group and and a bunch of other people as well. This is actually from them. So I promised we'll do it. We'll answer their question tonight. So it's a pleasure, Remax. We do what we can. So this is an actual matter where the problem with this is, the principle of huur gaat voor koop is something that we're talking about more in the last few weeks than we ever did before. Hey, Bruno, your Dutch is getting right up there with the amount of times we're discussing this. Because the reason why we're talking about this is because of COVID and because of the financial constraints that people are under during 2020, a lot of owners are forced to sell their properties. So a fully furnished property will lead to a whole new level of exciting things, not just in a lease agreement, but in an offer to purchase. So in most cases, it's simple. You buy the property, you don't buy the stuff in the property. In this case, exactly that. You bought the property, not the stuff in the property, but the property was rented out as a fully furnished unit. Now, to go into the detail of that, Bruno, I'll leave for discussion between you and I. But just for the benefit of our viewers, I just want to recap on huur gaat voor koop quickly. So the principle of huur gaat voor koop simply says, if there is a lease agreement in place and the landlord, as the owner of the property, sells the property, and then on transfer, the purchaser automatically ex lege, by way of law, without any addendums, without any sessions, without anything, becomes the landlord in terms of that lease agreement that's already existing. even though it says Bruno Stamau is the landlord, Marilee Schutte buys the property. On date of transfer, Marilee then, she doesn't become Bruno, but she steps into Bruno's shoes. Sounds a little gross and unhygienic and not COVID safe, but
there's nothing wrong with my shoes.
I don't mean to insult you on your birthday, Bruno.
I've got perfectly nice shoes.
So why this is relevant is all the terms in terms of that lease agreement, and then carries on to the purchaser. And the purchaser is responsible for all the rights, well, is responsible to comply with all the obligations of the landlord, but is also entitled to all the rights of the landlord. Then it carries on like nothing changed, because in his life, nothing actually changed, except he might pay his rent to another bank account, but that's it. So in this case, now there's a lot of things up in the air. So Bruno, over to you. What's the weird things on this one?
It's actually so interesting because you and I actually agree on the answer to this. And the one thing that people might not realize is when you sell a property and as a landlord, as a purchaser, you take over a lease agreement. Sometimes there's certain things in that lease agreement that aren't material or aren't specific to leasing. And we do kind of need to look at this and make a call on whether that portion of the lease is actually a lease that passes down through Huur, gaat, voor, koop, or whether it's an independent agreement that only carries a personal obligation between the previous owner and the tenant. So that's a little red flag for everyone to keep their eyes open for. It's not necessarily that the whole lease gets transplanted. There might be certain things that aren't lease specific. But to answer on this specific question, so what Silna mentioned is generally in the contracts, this would have to be dealt with. So it's quite disturbing that that no one looked at this and went, wait, but there's a bit of a problem here. This tenant is making use of these assets or these pieces of furniture. What's going to happen to these pieces of furniture? Is the previous owner simply going to go down and remove it? And my gut tells me that if there's nothing and everything's silent, it is the previous owner's furniture, which means that the new owner would actually have to replace the furniture if the previous owner were to take it away. Insofar as the repair of it goes, that's even more interesting, because there is an obligation, I feel, on the new owner to repair, but now technically it's the previous owner's furniture. So it's in their interest to actually repair it, but they don't have an obligation to the tenant. So it's this kind of weird dynamic where the new guy has to do it because the tenant's going to complain if he doesn't, but it's not actually his to repair. It's the previous owner's to repair. So maybe the previous owner should take responsibility. And I think in that instance, we also need to try to figure out what is the arrangement between the two. There has to be some kind of underlying arrangement. No one leaves their furniture somewhere and goes, well, whatever, like I'll think about it and deal with it later. Is there some kind of rental being paid back going, thank you for your furniture, let me pay you some rent for now so that I can keep using it? And all of these things would be specific in some form of contract. But yeah, if there isn't, then it does belong to the previous owner, but you as a new owner and landlord would have an obligation to repair it because it's your tenant.
And that's exactly, I think this is one of those unfortunate things where the rental agent gets caught with the actual big issue, where it was probably a different sales agent, or even just a transaction between the landlord and the purchaser and the seller, without an estate agent's assistance or without an attorney's assistance. Because and this is honestly with all the training and stuff I do for rental agents, this is exactly what I'm seeing. And seriously, sales agents, I'm not bashing you guys. I'm just saying, think of your rental friend that's also catching the ball, that's going to carry on. Remember, with a sale, you wrap it up, you finalize on transfer, all the parties, yes, we're hoping, walk away happily with their proceeds and whatever they need. and the property, and everybody is happy. With a rental, it's a continuous relationship. And I see it so often that because of the principles of Huur, gaat, voor, koop, the rental agent is sort of dropped in the middle, because remember, the rental agent's mandate also ends on transfer unless the purchaser mandates him to continue with the management of the rental. So very often nobody knows this, and the next moment the purchaser says, pay the deposit to me, and then the rental agent is like, whoa, I wasn't ready for this. We calculated my commission over the entire time period. Or in a case like this, clearly the rental agent is still involved and stays involved in the transaction, which is fantastic. But what I would like to see is to just talk to each other. The amount of times this year, Bruno, that we've said, guys, get around the table, pick up a phone, get on a Zoom call, talk to each other. I swear, if people talk to each other more, we just won't make money anymore. That's sad, and yet we encourage people to do that. But most of the time, we can avoid litigation, we can avoid big dramas like this simply by having a conversation with one another. Because my opinion on this is, if the furniture now belongs to the seller, and it's still, the lease agreement says that it's a furnished unit, there's an inventory showing that this particular dining room table, that particular flamboyant Christmas tree, and the interesting wall decorations that will freak somebody with OCD out for days. I'm sorry, Bruno. I don't know how you survive every Wednesday, but if you have an inventory saying that these items will be in the property, and the tenant pays rent with those items included, exactly to your point, Bruno, you would like to see some remuneration then to the seller, and that must have been dealt with in the offer to purchase. So I struggle to understand how that was missed and omitted. But I mean, things happen, and especially currently things are happening quite quickly, quite fast, and I can see how things are sort of accidentally left to the wayside. But I think it's important to know in this particular instance, whatever the lease agreement says, the purchaser, who's now the owner of the property, is 100% obliged to provide and to perform in terms of those provisions of the lease agreement. If that means he now has a damages claim against the seller on the basis of the offer to purchase, that could be the position. But unfortunately, contracts are made for divorces. That's why we have contracts. But we don't use our contracts, and we never read our contracts when things are going well. So remember, when you are entering into a contract or when you are drafting a contract, draft it with divorce in mind. Everything's not going to go smooth. Everything's not going to be happy and fluffy, and everybody's going to love each other and talk to each other and yay, in the spirit of Ubuntu and Christmas. Things will go wrong. And when it goes wrong, you want to make sure your lease agreement and your offer to purchase catered for it.
Yeah, absolutely. And what's interesting about something that you said now is we do, well, me and you specifically, we suggest that people actually engage, because we tend to interact with a lot of attorneys that the first thing that they say in their correspondence to us is, we will not litigate over correspondence. So they won't pick up the phone. They won't even speak to us when we're actually trying to get matters resolved. And I think that's something that me and you kind of share very much in common, is rather get the matter sorted out the way, get the client happy, than try to prolong it for as long as possible. And so when we're saying, listen, go speak to the guys, it's also not a cop-out to giving a specific answer going, this is the position in law, this is what happens. What we need to remember now is things the landlord hasn't considered. And Silna kind of touched on this, which clicked in my head. The new landlord now has furniture. I don't know what furniture he has. So now I'm presuming that it's a nice house, there's expensive furniture. What happens? So aside from the fact that somebody else's furniture is being used, what happens to wear and tear? Because we're speaking about remuneration for rental, right? But now, if nothing has been agreed, the tenant's using this property. There's wear and tear. So it's not just about repairs, repairing it, bringing it back to the state that it was. It's the ongoing use of this. And some of these things you cannot repair. And how do you actually compensate someone for a couch that starts getting worn down? And now it's not fair wear and tear accepted, because there's no agreement that accepts fair wear and tear. So is it replacement of the furniture? Because now you're using it. So are you going to inevitably have to replace it anyway with furniture that is of the same condition? So the landlord needs to consider he didn't dodge a bullet by keeping quiet and keeping the furniture and going, this is brilliant, I'm getting this furniture and I didn't have to pay a cent for it. This could very well backfire, because something happens to that furniture, even in the normal course of use. Seller's going to come in and say, cool, now it's time to pay me for use and possibly replacement and or replacement. And, here's the invoice.
It's a very, very interesting one. And I must say, what I do find is the type of questions we're getting from landlords, from owners, from tenants, and then from agents are so different. We get such a broad spectrum of questions. And on this one, I think our main answer is, let's go back to the contracts and just get the detail on what it says. And at the same time, seriously, we really feel for you, agents, because it's a difficult thing, and very often you get caught with the hot potato that you didn't even create, and it's a very scary place to be. And I think for us as attorneys, it's easier to sit from the side and say, yes, okay, it's a you problem or a you problem. If you are the agent that has to convey it's a you problem message, it's a much trickier position to be in.
Absolutely.
All right, perfect. That was quite interesting. Thank you so much, guys. And I think that is about the time that we have today for our episode. But thank you so much for joining me. And Bruno, enjoy the rest of your birthday.
Thank you.
And then we look forward to next week, our Christmas edition. So if you have any topics or questions, please post it on our page, and then we'll answer it next week. All right. Thank you, guys.
Cool. Cheers. Thanks, Marley. Thanks, everyone.
Okay.
Bye-bye. Happy birthday again. Enjoy the evening.
Thank you.
Bye.
Bye.